Welcome to the Proskauer Benefits Brief, legal insight on compensation and benefits. I'm Justin Alex, a partner at Proskauer.
And I'm Adam Scoll, also a partner at Proskauer. And today we will be discussing the Department of Labor's recent issuance of a much anticipated proposed regulation that would facilitate the inclusion of alternative assets, including crypto, private equity, private credit, and real estate, within designated investment alternatives offered under participant-directed defined contribution plans, such as 401k plans. These developments have been highly focused on and can have significant implications for so many different constituencies, including plan sponsors responsible for setting their plan's investment lineup, and obviously their plan participants, but also for all other fiduciaries, consultants, investment managers, private investment funds, mutual funds, and any other investment vehicles or accounts that directly or indirectly manage, advise, or accept investments from defined contribution plans or are thinking about doing so.
The proposed regulation implements President Trump's recent August 2025 executive order, which directed the DOL to relieve the regulatory burdens and litigation risk that have impeded investments in alternative assets by 401k plan participants. However, consistent with the DOL's historical practice of providing investment-neutral guidance, the proposed regulation applies to a plan fiduciary's selection of any type of designated investment alternative, or DIA, and not just those that include alternative assets. Importantly, the guidance doesn't apply to the selection of a brokerage window or self-directed brokerage account.
A critical piece of the proposed regulation is the inclusion of a process-based safe harbor that's intended to curb litigation risks and fiduciary fears with respect to the selection of DIAs. To that end, the proposed regulation identifies a non-exhaustive list of 6 factors for a plan fiduciary to consider when selecting DIAs, and includes numerous examples of how and when the safe harbor would or would not apply to certain investment scenarios and fact patterns. The proposed regulation further provides that a plan fiduciary's judgment regarding any such factor will be presumed prudent and entitled to significant deference to the extent the fiduciary follows the applicable safe harbor process for such factor.
So, by way of background, ERISA plan fiduciaries are required to act in accordance with the fiduciary responsibility provisions of Title I of ERISA, including the fiduciary duty of prudence. The ERISA fiduciary duty of prudence requires a fiduciary to discharge its duties with respect to a plan, and I'm going to quote here, with the care, skill, prudence, and diligence under the circumstances then prevailing that a prudent person acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character and with like aims.
And in 1979, the DOL issued an investment duties regulation providing that ERISA's duty of prudence is satisfied by a plan fiduciary when selecting an investment if the fiduciary both, 1, gives appropriate consideration to those facts and circumstances that, given the scope of the fiduciary's investment duties, it knows or should know are relevant to the particular investment, and 2, the fiduciary acted accordingly.
Right, and the proposed regulation supplements and expands on that 1979 regulation in the context of a planned fiduciary's selection of DIAs by demonstrating what it means for a fiduciary to act accordingly and therefore prudently for such purposes.
In the preamble, the DOL noted that the proposed regulation is built on 3 foundational principles. First, ERISA is a process-based law, and prudence is assessed based on a fiduciary's process conducted in connection with making an investment decision, not in hindsight based on results. Second, ERISA gives plan fiduciaries maximum discretion and flexibility in selecting DIAs, and so no per se rule prohibits any asset class within a DIA unless it is otherwise illegal. And third, when fiduciary decision-making follows a prudent process, like the one set forth in the proposed regulation safe harbor, the fiduciary should be entitled to a presumption that it acted prudently.
As we've already discussed, the proposed regulation identifies 6 non-exhaustive factors that are integral to the vast majority of DIAs that a planned fiduciary must objectively, thoroughly, and analytically consider when selecting DIAs. A fiduciary who follows the prescribed process is entitled to a presumption of having acted prudently and to significant deference with respect to their decision. The first of these factors is performance. The fiduciary must consider a reasonable number of similar alternatives and determine that the DIA's risk-adjusted expected returns over an appropriate time horizon and net of anticipated fees and expenses further the plan's purposes by enabling participants and beneficiaries to maximize their risk-adjusted net returns. Importantly, the proposal specifies that an appropriate time horizon for retirement savings may be long-term, and that a fiduciary isn't necessarily required to only consider recent performance.
The second factor is fees. The fiduciary must consider a reasonable number of similar alternatives and determine that the DIA's fees and expenses are appropriate, considering its risk-adjusted expected returns and any other quote unquote value the alternative provides. Value includes benefits, features, or services beyond risk-adjusted net returns. Accordingly, the proposal acknowledges that a fiduciary is not necessarily always required to pick the lowest cost alternative.
The third factor is liquidity. The fiduciary must consider and determine that the DIA will have sufficient liquidity to meet the plan's anticipated needs at both the plan and individual participant levels.
And the fourth factor is valuation. The fiduciary must consider and determine that the DIA has adopted adequate measures to ensure timely and accurate valuation in accordance with the plan's needs.
The fifth factor is performance benchmarks. The fiduciary must consider and determine that each DIA has a meaningful benchmark and then compare the DIA's risk-adjusted expected returns net of fees to that benchmark. A meaningful benchmark is an investment strategy, index, or other comparator with similar mandates, strategies, objectives, and risks. The proposed regulation accommodates innovation by clarifying that there is no presumption against new or innovative DIA designs that might not have any clear existing benchmarks. In those cases, fiduciaries should identify the best available comparators when analyzing the new design's value proposition.
And the sixth and last factor is complexity. The fiduciary must consider the DIA's complexity and determine whether she has the skills, knowledge, experience, and capacity to understand it sufficiently, or whether she must seek assistance from an expert.
The DOL is seeking comments from interested parties on the proposed regulation, and those comments are due by June 1st, 2026. As you can imagine, if adopted, the proposed regulation would have significant implications on a broad array of parties that directly or indirectly manage, advise, or invest the assets of 401k plans or are considering doing so.
Importantly, for now, these are just proposed regulations, and many questions remain unanswered, and so we will keep you posted on any new developments. If you found this useful, be sure to follow us and subscribe on Apple Podcasts, Spotify, and YouTube so you do not miss the next episode. And if you are interested in hearing more from us live on this topic, be sure to reach out about attending Proskauer's Compensation and Benefits Symposium taking place in our New York office on Thursday, April 30th. I'm Adam Scoll.
And I'm Justin Alex. Thanks for listening to the Proskauer Benefits Brief.